Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights and legal issues, bringing you information and analysis. My name is Dumile Mateza. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. The idea that powerful organizations with private interests may capture the government in order to foster their private goals is certainly not a recent one. But the concept of regulatory capture has been introduced in modern economics analysis for the first time by Dr. George Joseph Stigler in his paper, The Theory of Economic Regulation, aptly known as capture. According to a paper by the Center for the Study of Democracy, published in August, state capture could be defined as a combination of different forms of corruption which have a single objective: to secure wholesale by default and long-term privilege to captors by exploiting the power of government for private benefit. In the light of the State of Capture report of the Office of the Public Protector, this week, Rights and Recourse, we take a look at this phenomenon as captured, excuse the pun, in this groundbreaking report. To discuss today's topic, we are joined in the studio by Ms. Brenda Wardle from the Wardle College of Law, and Mr. Ralph Mateka, a political analyst, an independent political analyst, and from our studios in Cape Town, we will be joined later by Professor Kathy Powell from the University of Cape Town's Department of Public Law. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse.
Thank you, good afternoon.
Thank you. The question, Ralph, I want to ask is, what do we understand state capture to be? Is it something that relates to corruption or is it facilitation?
Well, let's look at the goals of this transaction that we have come to call it state capture. It's actually about coordination by interest groups to try to dominate the narratives within society, to try to influence the pattern of distribution of resources within society. And in order for them to be able to achieve that, they tend to dominate and influence the decision of political decision makers. And you can say that they tend to become an intermediary between the voters and the elected officials, in a sense distorting maybe that relationship between the voters and the elected individuals who serve in government. That is actually the purpose. It can take various different forms depending on the society, but the end result of it is a malicious way to try to influence result and to try to make sure that the pattern of distribution of resources is in the interest of that interest group that defined itself within that setting.
But you might have a view on this, but I want to put this question to that too. So many scholars regard state capture as lobbying. In America, this is a very well-known thing. But when does lobbying become state capture?
You see, state capture, as you correctly pointed out in that paper, has the element of corruption in it. And if we look at the United States, we are always told, there was a paper released last week, that the President of the United States is basically a figurehead, and there is a powerful lobby group, and this is one of the sad symptoms of capitalism, that the wealthier people are, the more access they need to resources, and those resources are both private resources as well as public resources.
To turn to what Brenda is saying, Ralph, there's something in America when they talk about American elections, there's something called the strong Jewish lobby. When does this lobby become state capturers?
Well, one of the organizations that is at the forefront of the so-called Jewish lobby is AIPAC. I think it's American International Public Affairs Committee. They've got a very strong Jewish presence. They represent the interest of Israel, actually. It's nearly impossible even for any sitting president in the United States to go against that. But if you ask them, are they capturing, or they will tell you that they are using transparent means to try to influence the decision. Usually they will go after particular particular senators for a particular position, foreign relations, maybe division within Congress and so forth. Their aim is to try to make sure that the Israeli interests are always protected. They are saying they are doing it openly, but not all the activities are open. To some extent, you have some clandestine intimidation. Part of this state capture, as Brenda is saying, there is corruption, there is a little bit of gangsterism within that, couched in nice suits, if you like, where you have people who are intimidating others not to take
where decisions are made in smoke-filled rooms.
Exactly.
And with the opinions, and in South Africa we suffer from that same malaise where we never ever want to acknowledge something commendable or concrete if it comes from an oppositional view. So you are either in this camp or that camp, or this political party and that political party, and that is where the discourse becomes problematic. Because going back to the United States currently, if you look at the liberals, they'll tell you that there was no corruption, and it's a pity that we can't take the public protector's report, for example, and map it so that we actually see as an image the impact and tie all these little dots together. But it's really a tough period for South Africa.
When you talk about when we talk about this, I seem to remember during the apartheid years we had the Afrikaner Broederbond, and every decision that was taken by government was first discussed at smoke-filled room of the Afrikaner Broederbond somewhere in Broederstroom, and before they go to parliament. In other words, decisions were taken there before they go to parliament. Was that a form of state capture?
Well, it was a form of proliferating influence. Actually, the Broederbond and those organizations were very influential when it comes to the direction that the African the apartheid state took. And actually, if you look at, if you take that point of view, you look at what is happening today, you could actually argue that what we are seeing now, the debate, partially what is happening, is a contest by another group, maybe that it's a contest for the state capture by different interest group. We tend to think we're talking about a single interest group, which could be the group that's here. No, that's wrong. There is an element of an interest group. The inherited Afrikaner capital is part of this, but also you could actually even go further and distinguish to say that maybe another group might have emerged under President Nelson Mandela towards the beginning of President Mbeki. So it is a contest.
You say that, Ralph, there is a picture, when I was doing research, I came across a picture that was talking about state capture during President Mandela's time, where President Mandela is walking next to Anton Rupert,
yes,
and holding Anton Rupert on the shoulder. And I said, this must be a telling picture for those people who say state capture in South Africa is not new.
It's not new at all. And actually, I say that one of the conditions for transformation, one of the issues that were negotiated during transformation in South Africa around 1990 was that the ANC-led government was asked not to vandalize the economy, not to get its hand too much within the economy. Who did that? It could only be the previous dominant interest group that were capital, that were interest during then. So I think that while we are at this debate, let's just go all the way out. Let's identify various groups within South Africa that have got a motivation to actually capture the state and carry out a thorough analysis so that we are not just looking at people who are having crumbs. I'm not saying the amount is insignificant, but we need to look deeper, because I think that this issue is much bigger than the current capturers, who are found to be very clumsy compared to the previous one under apartheid.
I think if we look at what Bishop Mpumlwana said, which I disagree with, is that this needs to go back to the early 90s. But if one says so, you read the report from the Institute of Security Studies on the looting, grand-style apartheid corruption, pre-democracy. And you ask yourself, if we are going to investigate state capture, how far back should we really go? Because in the public discourse, what is happening currently is that everybody who says President Zuma is a thief, the Guptas are capturing, tends to limit this wider network of capturing to one company and a few individuals as well as the president, without actually saying, let's take a step back and actually look where the rot started. And perhaps truly we need a TRC on economic matters where people can come forward and say, this is the extent to which we looted, and obviously be granted pardons for telling the truth.
Well, if you'd like to join us in today's discussion, you can call us on 011 714 5497 or 5498. Alternatively, you can tweet us at Rights Recourse. When we come back, we will be joined by Professor Kathy Powell, who is in our studios in Sea Point in Cape Town. Stay with us.
A presumed U.S. drone strike in the south of the country has killed 3 al-Qaeda suspects.
Death toll in Yemen's 18-month-old civil war now stands at about 10,000.
People get killed or die and are actually buried before they're recorded, and we don't have a way of recording that, but we know the numbers are much higher.
Water restrictions are to be imposed on villages in and around the Nkomazi municipality.
Pumps can't pump the water because there's no water in a river, and if the water is coming back, then it's full of mud.
Those who can pray and those who can do any miracle to make sure that we've got enough rain, give it a try.
Welcome back to Rights and Recourse as we discuss state capture. A report of the Public Protector came out this week after a court decision that the report should come out. One of the questions, I just want to give Dr. Powell an opportunity to catch her breath. There are many people who believe that this investigation was rushed, and there are many gaps, apparently, according to some people, but I didn't see gaps when I read it. Probably we should do more of these kind of things. Why was it important that this should be investigated? The Public Protector speaks about, because there's an executive ethics complaint coming from the leader of the DA, it had to be done within 30 days.
Well, the Public Protector is under an obligation to investigate all complaints that come to her office. But we do understand that this is of major public interest. It involves members of the executive. Serious allegations were made in the media by Fakey Mentor, by Deputy Minister of Finance, SABC Jonas. So there was nothing wrong in the Public Protector investigating that. She was duty bound. Had she not done that, then obviously she would have gone against her constitutional duty. The Public Protectors Act then stipulates that 30-day period, which of course may be extended. But yes, the report, in my view, was rushed. I did pick up in the introductory paragraphs a few errors, but that being said, the gist and the merits are still discernible from the report.
Dr. Kathy Powell, you wanted to say something around that very question.
Yes, please. The report had to be rushed. There was a time constraint. And what the Public Protector did in order to deal with a coherent piece of the allegations that were brought before and the suspicions that were raised was to divide the investigation up into different segments. And she specifically said she would be doing only phase 1. Now, phase 1 includes the complaint that was raised under the Executive Members Ethics Act, which, as your previous speaker has said, has to be dealt with within 30 days. What she also did in order to deal with the issue properly within that short period was not to make any adverse findings, but to make findings on particular events that had to now be investigated by a judicial commission. She explains in her interview with President Zuma and on other occasions, that it is very unusual with inquiries of this sort to change people halfway. In judicial cases, a judge will actually be brought back from retirement to finish a part-heard case. The same thing happens in the CCMA. So what she wanted to make sure she did was to finish properly a portion of the report, and all her findings there are valid and tested. And yes, I spotted a couple of typos too, but given the time constraint she was under, I think she did really well. She also, of course, had to deal with delaying tactics by President Zuma, amongst others, so she had to process some of the information quite late in the day.
Let's take this call from Senzo from Johannesburg. Senzo, good afternoon and welcome to Rights and Recourse.
Yes, good afternoon. How are you, and how are you to the viewers?
Fine, thank you, Senzo.
Yes, I'd like to contribute 3 main points with regards to the state capture debate. Number one, I would like to first agree with the lady that suggested the economic TRC. I think that's an absolute necessity. It will give an opportunity to a number of people who have covertly exploited the state, and we regard them as they are in good state of play in terms of their reputation. So in a nutshell, I do agree that we do need an economic TRC. And then when it comes to the question of the Commission of Inquiry, I would like to commend Thuli Madonsela for taking that direction. In that way, everyone will be given an opportunity to answer the questions that they did not get an opportunity to answer, and to also exercise their constitutional right of giving an opportunity to respond to anything that has been alleged against them. And more importantly, I would like to indicate a very crucial point in terms of the state capture, that it's not a new phenomenon. The state has been captured, but it has been captured in a form of a neo-colonialism, whereby people who are pulling the strings are not in the open. But now there's a competition between the state being captured from the context of neo-colonialism and the state being captured by what I call black imperialism. The Guptas, I classify them as black. So now they're pushing an agenda of black, trying to imperialize the South Africa for the benefit of the few.
Thank you, Sir Senzo. Senzo have made us a number of points there, or agreeing with what Brenda was raising earlier, support Bishop Malusi Mpumlwana's SABC say there must be a TRC. Looks like this TRC is going to look at a number of things. And also the fact that the Judicial Commission of Inquiry that has been called. Now, talking about the Judicial Commission of Inquiry, I want to come back to something that many people, for instance, are now talking about taking the Public Protector's report on review. Isn't that going to be a duplication? You're going to have a Judicial Commission of Inquiry and people taking the Public Protector's report on review, or should those run concurrently? Can that happen? Because the same issues are going to be ventilated that are going to be ventilated in the review are going to be ventilated in the Judicial Commission.
Well, the idea that there should be a Judicial Commission of Inquiry is one of the recommendations within the Public Protector's report. And if it is indeed that a recommendation, it means if you're going to review the Public Protector's report, you go to court, there is a possibility that the court might come up and say that there is no need for Judicial Commission of Inquiry. What I'm trying to say is that as much as there might be overwhelming evidence that there need to be that inquiry, in terms of the principle, you cannot preempt the results of the court. If people are taking it upon review, you cannot have a Commission of Inquiry. You have to wait for the court procedure to be undertaken to give you the validity of that report, because the court will be saying that this is valid here and there. And also those who are taking this report upon review, it doesn't mean they have to take up everything upon review. One might take you might take a remedial action upon review that I don't think this is a good cause, or maybe some of the substantive arguments made in the report, or findings or assertions made in the report thereof. I think you have to allow that process to be able to finish. And looking at the number of people who are implicated into this, I think that we are going to just see a lot of people march into court. It might be a slightly longer process to just establish whether this report has to be implemented as it is, or it has a problem, and as the court might find out.
What I would like to add to that, Rumile, is that review grounds are not endless. So you do not just take the report or the decision, challenge the decision of the public protector in court on review. But I want to go back to the issue you raised about parallel processes. The public protector made it clear that this was the final report of the first phase. There is a second and a subsequent report envisaged. Those investigations and subsequent reports, in my opinion, would be superfluous if the Judicial Commission of Inquiry is established. When it comes to the Judicial Commission of Inquiry, and this is the one limited ground on which I feel they could, those implicated or even the new public protector can challenge the report in court, is to say Thuli Madonsela did not have the right to say that Justice Mukhweng must be the one to select, because the establishment of commissions of inquiry are enshrined in the Constitution. So in a way she was amending legislation, and the public protector's office is actually a creature of statute. That is the one problem that I had with those recommendations. Other than that, I see very, very little grounds for people to say, well, we weren't afforded an opportunity to ventilate ourselves.
Let's hear Dr.
I'd like to add some points to that, please.
Yes, go ahead, Dr. Powell.
Thank you very much. Couple of things. Firstly, there's a difference between review of a decision and the Judicial Commission of Inquiry. As Brenda Wardle said, review is limited to a few grounds, and they're mainly procedural. Now, the only grounds that have been identified so far by the implicated parties on which they'd like to take the decision on review is that they weren't offered an opportunity to present their side of the case before any adverse findings were made against them. Now, the report doesn't actually make any adverse findings. It spots omissions, and these are omissions by members of the executive to ensure that the areas under their control and under their responsibility do not result in corruption or improper enrichment for people. So she hasn't actually made any adverse findings. Then the second thing is that this whole idea of hers that the Judicial Commission of Inquiry should be headed by a judge appointed by Judge Mukhweng. That's an interesting legal point. It's unclear at this stage to say where a court would go on that, but we must just note two things. First of all, in the report, Advocate Madonsela specifically states that the reason it would be appropriate for Judge Mukhweng to appoint the judge is so that Jacob Zuma is not seen to be a judge and jury in his own cause. That was one of the reasons he resisted instigating an investigation in the Nkandla report. That was the reason he actually gave. And the other thing is, Section 84 of the Constitution simply gives the President, I beg your pardon, the power to institute a commission of inquiry. It doesn't expressly set out any limits on that power, but limits have been found in the case law. For example, the principle of legality and rationality. Now, the public protector is not a creature of statute, but an office created by the Constitution itself. And what she's trying to do in this case is to make sure that justice is not only done, but to be seen to be done. And for that reason, it may be necessary that when you're dealing with a report where the President himself is implicated, that he does not in fact appoint a judge who conducts the Commission of Inquiry.
Well, if you still would like to join us here today in this discussion, you can call us on 011 714 5497 or 5498. Alternatively, email your thoughts to write to Recourse at sabc.co.za. Stay with us.
Whether you're looking for a restaurant, public transport, or a university, a lot of us use our smartphone apps to find the closest one. On Network, we chat to those who play a role in Africa's tech space.
We have taken financial services closer to the people. Yeah, mobile penetration is pretty high.
Apple take 30%, keep 70%.
On Network, we give you Africa's social media and technology news. That's Network with Ms. Phumelele Zondi every Sunday at 7:30 p.m. Central African Time.
Young girls crossing our borders often find themselves alone in the big city of Johannesburg.
I came here when my pregnancy was 6 months.
Like many other girls from Zimbabwe, Abigail found her way here to the Central Methodist Church.
My friend who was raped, who was forced to have sex at the church.
I insisted that this needed to be handled with the police.
I think we don't have rights. You do what you don't want to do and you'll be forced.
Any refugee in a strange country is vulnerable to forms of abuse and manipulation.
I don't have any option. I can just continue to put the guys so that I can take care of my baby.
Welcome back to Rights and Recourse as we discuss the State of Capture report so that we all can understand what it means. A thick document. I actually had to divide it when I was printing it into two, and they're both just big documents. The question I wanted to ask is, let's first start with Peter from Johannesburg. Peter, good afternoon and welcome to Rights and Recourse.
Good afternoon, panel.
Afternoon.
Good afternoon, Peter.
I just want to get straight to the point. Brenda Waddle has hit the nail on the head. This is the finest program that has got to the truth. The truth is, the report that Tuli Madonsela wrote up is a report on inconsistency. It has nothing to do with state capture. The state capture is an item like the apartheid days where we suffered as struggle activists, when we had old rules like divided rule. Look at the scenario. Our most seasoned leaders at the moment are being crucified, even including people like Sean Abrahams, who is a qualified advocate, President Zuma, Praveen Gordon, you name it and it's there. What I want to say to the panel, South Africa is under siege, and the siege is a political ploy. The issue about the Guptas is no news to people like us, because a company that is using strong customer relationship management techniques are doing the right thing. Maybe it's inconsistent. You can go into a judicial inquiry, you can do what you feel like. But I say that my lady there, Ms. Waddle, has hit the nail on the head. We in South Africa need to look at where these divide and rule tactics of the apartheid days are coming from. Thank you.
Thank you, Peter. That's a very strong view from Peter there. I don't really want to respond to that. First, he said a number of things. It seems to be saying this is a political ploy that is aimed at, he didn't say it in many words, at regime change.
I do think that there are many interest groups that seems to want to also hijack this debate and to achieve certain political goals. But I still think that there are certain specific transactions that need to be investigated. Remember, if you go through the Public Protector's report, and I've also even listened to her giving different media interviews.
I had something to add.
She shies away from the use of the concept state capture. She actually says that she's looking at specific incidents or transaction that involves Executive Ethics Members Act, allegations that members might have violated that, members of the executive. She's trying to narrow it to that. So that for me says that yes, you can investigate those specific transactions within the given time, and if you couldn't finish it as the public protector, you could actually forward it to other state institutions to carry out investigation in relation to those specific transactions. But I think the question that remains remain unattended. And I think that is what Brenda is outlining, is what then do we do with the bigger objective of state capture? The whole suspicion that has been there, what do we do? And that is what Peter is also saying, that there are others. South Africa is under siege. And I agree, South Africa is under siege, but from different corners, and to some extent also from the previous capturers, maybe the newer capturers, and perhaps even the wannabe capturers.
Let's get a view from Dr. Powell. Dr. Powell, from that, I think you heard that comment from Peter.
I certainly did, and the comments that other members of the panel made in response. Let's just start at the beginning, which is this is a legal question. The law is in fact only manipulatable to a certain point by politics. Sometimes the legal position will be of political advantage to one side or another, but the legal position itself is actually neutral. Now, what Thuli Madonsela has been investigating here is a violation of the Constitution and the law. To call that an attack on the veterans or the leaders or the prominent people is to in fact call the law an instrument of violence or to claim that it can be manipulated. Now, our whole Constitution is founded on the idea of the rule of law. And in fact, that is one of the criticisms of Sean Abrahams, was that he brought charges that were not supportable by law, and that was explained by legal experts at the time. So again, to call a criticism of his misuse of the law a political attack is to ignore the fact that law sets certain parameters for how society is supposed to work. And that is exactly what we're supposed to do about state capture, is we keep applying the law. The Office of the Public Protector keeps following up on any complaints that gets made, and the judicial inquiry gets held to find out the details of who and how was improperly benefited in this case, and how those funds can be retained or recovered for the people of South Africa. So there's a lot we can do about state capture. We don't need to be too upset that it's been happening for years and years. We stick to the law. We check that there's no more misuse of public funds or conflicts of interest, and gradually society can recover from the years and years of abuse.
Brenda, I know you've been burning. I went to Dr. Powell because I saw Dr. Powell a little bit restless. The other question is, the public protector left, or Advocate Madonsela, let me not say the Advocate Madonsela left a lot of gaps in this report and said there'd be a follow-up later to investigate certain other things that are also in this state of capture.
It goes back, what you are saying goes back to what I was saying earlier, that in my opinion, yes, she's completed the first phase, she's issued a final report in that regard, and I'm saying because she's recommended a judicial commission of inquiry, we might disagree on whether or not she has the powers to select Justice Mogoeng and motives aside. But what should happen here is that the Commission of Inquiry needs to kick off so that all sides can be heard. It's very important that we hear the other side, or the old legal maxim, the audi altrum partem rule.
Can I take it that you are saying there's no need for review because the Judicial Commission of Inquiry will be a review itself?
It's not going to be a review. It will be an investigation into these allegations, a further and in-depth investigation.
My actual question was, in fact, let me just take this call from Pulukwane from Anonymous. Anonymous, good afternoon and welcome to Rights and Recourse.
Good afternoon to the panel.
Afternoon.
Good afternoon.
Yes. I would like to make a comment around this debate, because it's very unfortunate as ordinary South Africans what we see happening. The Public Protector's Office has been used for political in battles. I mean, already the report that has been issued, it has incriminated a lot of people in a way that even if we go to the judicial review, already people's reputation has been tested. But the question that I have is, why did the previous public protector not wait until a full investigation is done, so that a full report can be
Daniela, I have an
published?
answer to that, please.
Yes, because now, already now...
Thank you, Anonymous. Anonymous, yes, we heard you. Why did the public protector not wait until there was enough time to do a full report? And I think the public protector has taken care of that. And I don't understand where probably... Kathy, Dr. Powell, let me leave it to you. He's saying, Anonymous is saying, the public protector's office has been used for political nefarious reasons.
Political gain. Yes, well, that was the issue I was referring to a moment ago. If the law is being applied correctly, and one can check on that, and there are courts to do it, it may be that the legal position is to the advantage of one political party or another. For example, if Jacob Zuma has been involved in corruption, obviously this is to the political advantage of the opposition parties. There's no doubt about that. That doesn't mean we don't investigate allegations of corruption. What we do is we make sure that those investigations are procedurally correct. Now, what the public protector did was to cordon off a certain part of the investigation that was the most urgent, and that involves essentially the failure of the executive to prevent conflicts of interest. As part of that, she looked mainly at the relationship between Eskom and Tegeta. Now, that's it, facts. I'm afraid you can't get around facts. And yes, people have been implicated, but a judicial inquiry will give them the chance to clear their names completely. So we needn't feel that because there's been a report, some people have been unfairly besmirched. They've now got the chance. In fact, for the first time, because this stuff has been in the media for months, years even, they've got for the first time the chance to defend themselves with their facts and their evidence before a court of law.
Let me come back to something else. The question I actually wanted to ask, is the public protector, the incumbent, obliged to follow up on the things that Advocate Madonsela did not left to be done, to say we'll come back to this again? Is she obliged?
I think if the report is not successfully set aside in some form of a review in court, the public protector is obliged to do that. Is obliged to follow through and make sure that those outstanding issues need to be investigated further. And I think that, here, I don't know what was the motivation on the side of Advocate Madonsela. She seems to have been very suspicious as to whether there will be any meaningful investigation upon her departure. Hence, I think Dr. Powell is using the term cordon off. I agree. She seems to have laid the track as to how the train is going to have to move forward. And I think the suspicion maybe is because of looking at how the public interest into that issue, the time that the report was released, the fact that it was actually interdicted, the preservation order and all that. Maybe that built to that situation justifies that situation as to maybe the decision as to why should there be prescription as to how to go forward when it comes to further investigation. So the new public protector is obliged, unless otherwise that is set aside in the form of
she is obliged.
Brenda, I know you are burning to come into this. Let's take this call from September from Cape Town. September, good afternoon and welcome to Rights and Recourse. Are you there?
Hello, yes. I'm here. How are you doing today?
Fine, thanks. How are you?
Okay.
Come, Mr. September.
I just wanted to raise the issue of, I just want to first say that I'm in support of, one of your guests mentioned the TRC process on economic capture, right? Going back to pre-1994, I think that is a wonderful and marvelous idea. I think it needs to happen. I don't know if you can remember a few years ago, I think it was in 2009, Christo Visser was caught with a few 100,000 rand at a UK airport. And at that time, it was during the court proceedings, it actually came out that that money came about from diamonds that were smuggled out of South Africa and stashed in a UK safety deposit box. I think that we need to understand how did that sort of funds leave South Africa in the first place, considering there was sanctions and all of that sort of things happening. I also understand, I belong to the Greater Cape Town Civic Alliance, and since about 2008, we have been raising the issue of state capture within the city of Cape Town. And with organizations like the Western Cape Property Development Forum, which a business plan
Mr. September, we are not going to be able to take every nitty-gritty that comes from Cape Town. Probably we should talk universally when we talk about these things on a program like this. But we've heard what you are saying. We support it at TRC in economics. You raise the issue of Crystal Visa being caught with a great deal of money in an airport in the UK. But let me hear from the guests. What do they say to what Mr. September just said?
Well, what Mr. September just says, I think I didn't hear the latter part of his argument, but as I pointed out earlier, the debate is much larger. However, we have before us this creature, which is the state of capture report. That is the first point I would like to make. The second point I would like to make is that it is almost as though Advocate Busisiwe Mkhwebane is non-existent. And I read a media report where she actually said, this report is not a report of Advocate Thuli Madonsela in her personal capacity. It is a report of the Office of the Public Protector, and all queries in relation to this report should be directed to her office. She went further to say that she accepts the report and the previous successes and failures of the previous public protector. The last comment I want to make, the last comment that I want to make in relation to that, Dumile, is that one criticism I have against Advocate Madonsela is her playing to the gallery, even saying that civil society will ensure that action is taken against President Zuma. She should be independent.
Shouldn't civil society ensure that?
Yes, but it shouldn't come from her. I can say that.
It can come from anybody.
You can say that. Anybody else.
It can come from
but
anybody.
she needs no. I disagree with that. I disagree with that.
She broke the rules by saying that?
No, I'm not saying she broke the rules, but it actually gives credence to the criticisms, sometimes unfair criticisms, which are labeled against her from certain quarters. There must be objectivity. She's done a great thing. She's issued the report, allow South Africa to make up their minds and to discuss the report.
Dr. Powell, you wanted to come in something earlier.
Yes, thank you very much. We seem to have got onto the person of Thuli Madonsela. Just a small point, responding to Ralph Mateka's argument earlier on, or his suggestion that she may not have trusted a successor. She does give a lot of reasons for wanting to complete phase one of the report herself that are completely unrelated to the merits or demerits of her successor. So I think you might not quite believe that those were her entire motives, but they are good reasons. She talks about institutional memory. She talks about the fact that cases don't get part heard in tribunals. She names a number of factors and of course, there's the fact that the Executive Members Ethics Act requires quick processing. So she does give factors that would need her to do that first part of the job.
Let us.
Secondly,
can you hold that thought? Can you hold that thought? We have a long distance call from Windhoek in Namibia. Dee, good afternoon and welcome to Rights and Recourse.
Good afternoon. How are you doing?
Fine, thanks. How are you?
I'm good. I just want to ask a very little small question, maybe two or three. Is that maybe a matter of the law and the constitution is far differ from ours here now? Maybe if an ordinary citizen commits crime or maybe alleged to be said he committed crime or something, is it not the same thing as a high-profile politician official commit crime? They have to be treated the same. Because I see in South Africa it seems to be very different from here. Since maybe there is a allege of those high-profile official or maybe government and compared to the ordinary citizens, the high-profile politicians are given a privilege of treated special than ordinary citizens. I think that maybe you are surprised, but I see they are even created a special inquiry first before they appear in court. Is that maybe can you or maybe you have to clarify on that? That's a matter of question.
Thank you, Dee. Thank you, Dee. You want to come in first? Who wants to take a first part of what Dee is saying?
I was actually going to say that yes, we are all equal before the law, and we ought to be treated in the same fashion. However, when it comes to high-profile cases, that perception is created that they are treated differently. If we go back to Jackie Selebi, etc., and other even Pravin Gordhan's prosecution, it creates the storm in the public sphere. But I think the caller, Dee, actually asked a very, very pertinent question, because ordinary people sitting at home ask themselves, but I didn't have all these advantages which are being afforded, which in terms of the law are there.
I think you're bringing us to another point. I think Brian and Dr. Powell, the issue of when the banks decide to close the bank accounts of Oak Bay, the cabinet sits and discusses this thing. And I had about 12 years, no, not 12 years, 2012, I had my account closed by Nedbank. If I knew that I could go to the cabinet to fight on my behalf of Nedbank, I would have done so.
Kathy?
Indeed. That's a good point, and I'd like to respond to your point as well as the call by the person from Namibia. Yes and no. We should all be equal to the law. And one of the ways in which the high-profile cases have given an undue benefit to the implicated persons is that certainly in the case of, for example, the spy tapes and this public protector's report, Jacob Zuma has had access to state funds to run his legal battles. So the spy tape saga went on for 7 to 9 years, all on taxpayers' money. This may now have ended after the recent court case, the recent order said that Jacob Zuma should bear the legal costs himself, although I understand that he can still make a case that should not be so. But there's another sense in which actually there is a different rule for the high-profile cases and for ordinary citizens. And that is that when we're dealing with the high-profile cases, we're not just dealing with individuals, we're dealing with organs of government. So, for example, the allegations that the Constitution and the legislation have been violated are allegations against the executive. So the executive as a body, cabinet, for example, cabinet intervening in that decision of the banks to close the Gupta accounts. Now, cabinet doesn't have any rights. Individuals have rights. Cabinet is the government, and it actually has only responsibilities. Cabinet can't say, in the same way that Sean Abrams have said, there's no proof that there's political interference. They're the ones who have to prove on an ongoing basis that there is no political interference. That's called accountability. So the individuals within the institutions, sure, they have the same guarantees as we have, and that is why we must have a judicial inquiry. But the institutions, they have actually got an increased level of care, and up to now that has not really been demanded of them.
Brian, this is something else. We now know the president took the public protector to court for the report not to come out. Now there's now proof that there is an audio that has come out of an interview between the public protector, Thuli Madonsela, and the president. And the president actually has gotten wind of this, and they've actually probably heard of it. They're now saying they are thinking of putting a formal complaint to the Office of the Public Protector because they believe that this audio was leaked.
I've been of the view that the conversation between the president and the public protector regarding investigation is supposed to be public record anyway. I'm just concerned that it looks like the president wants to invoke a type of privilege that doesn't belong within this. And I also think that the privilege also that seems to have, there was an attempt to invoke it, was that of interviewing everyone else who has come before the public protector. I think I've been to law school. I don't know I don't know the basis for that. Also looking at the Public Protector's report, looking at the Public Protector Act, I don't know what is the basis of that for the president to complain about that. These things are public record. There is a growing perception or maybe a strength within the executive. They tend to forget, they are public official, that everything they do has to be in the public interest.
Brenda.
Exactly.
Yes, Dumile, I would say firstly, complaining to the Office of the Public Protector about whether the recordings were leaked or not. It's regrettable that there have been leaks from the Office of the Public Protector, and this goes against the spirit of the Public Protector Act.
May I respond?
However, be that as it may, I don't think the President has a basis now, because it's the report itself is out in the public, and therefore anything else which informed the report is also public, and it might have been in a way a retaliation, if I can put it in that way, that you are alleging that your right to interview the witnesses, which he does have in terms of the Public Protector Act through the Public Protector, have been violated. So because you are arguing that you weren't afforded an opportunity, you weren't given a hearing before the release of the report, come, let's do this and then ensure that the recordings are made public.
Well, the other thing for me, I do not understand why it would be a view that the recordings were leaked, because there's 89 pages in the report of a transcript of a discussion between the President and the Public Protector. Dr. Powell?
Yes, I'd like to pick up on that. Yes, thank you. That is what I was thinking. It's not a leak. She published it as part with the report. And she published it, firstly, she had every right to do so, because as much material as possible from her investigations should be made available for public record. That's part of the her accountability process. And secondly, she had to publish it, given that one of the grounds of review that's being suggested is that she did not give implicated and affected persons the chance to reply to the case against them. Now, in that 89-page document, or the 4-hour interview, you see President Jacob Zuma and his lawyer, Michael Hulley, refusing for 4 hours to answer the questions and present their side of the case that she presents to them. So it is actually necessary for her to show, as a matter of procedure, that she followed the correct procedure to give the transcript of that interview.
Brian, I'm sorry, I keep on saying Brian. Brian has been on my tongue since last Thursday.
Not Brian
Ralph, you seem to know, you and the President seem to know something we don't. Yesterday, the President said he's not afraid to go to jail. He's been to jail. You seem to be sitting there with a book called When Zuma Goes. What do you know that we don't?
Well, there is nothing that I could say I know that people don't, but I think that we also need to understand that the debate on the state capture also allows for president's people to defend themselves, and they are invoking that. And what they are saying, actually, there is a narrative that seems to be gathering, and I'm not surprised it's coming out from the corner, president's corner, that says that one of the callers confirmed it. We are under siege. There are people who are setting this narrative, painting us as all corrupt. Actually, we are not even in charge. If you want to know who actually is in charge when it comes to influencing the economy and so forth, maybe they are saying we will tell you. They are making this to be a point of a liberation movement that is under siege. Of course, it is a defense. It is the narrative that the president is trying. And the reality is that the history of this country just doesn't allow you to deal with this question of state capture. As much as it speaks about specific transgression, it doesn't allow you to deal with it without slightly going back to the past. You've got to have to go to the past.
Ladies and gentlemen, I'm sorry, we've quickly run out of time. It was a riveting discussion. I want to thank all of you for coming out. Dr. Powell in Cape Town, Brenda Wardle and Brian. Sometimes we'll get some time to talk about more other things we haven't spoken about. I wanted to go into state governance in the state-owned enterprises. It's something that I would like to talk to you about. But in closing, I would like to quote from the I Have a Dream speech by Dr. Martin Luther King. In a sense, we've come to the nation's capital to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. It is obvious today that America has defaulted on this promissory note in as far as citizens of color are concerned. Instead of honoring this sacred obligation, America has given the Negro people a bad check, a check which has come back marked insufficient funds. But we refuse to believe that the Bank of Justice is bankrupt. We refuse to believe that there are insufficient funds in the great vaults of opportunity of this nation. So we've come to cash this check, a check that will give us upon demand the riches of freedom and the security of justice. The views expressed on this show don't necessarily reflect those of the SABC or Rights on Recourse. This program is repeated at 5 on Wednesday morning. From all of us here in the studio, good afternoon.